All right. Hello, everyone. I'm Cindy Slack at Keller Williams, and welcome to our first 2020 educational series. We are listening to a lot of what our clients are asking for, and there's been a lot of questions about Prop 19, which passed in November, and how it affects homeownership is always important. So today I've invited Wesley Williams to join us, and he has uh, a PowerPoint presentation, and we'll be able to answer some of your questions. I do want to make sure that I let you know this is a summary. I don't know how deep we're going to get into some of these things, and a lot of it is still out for speculation. We might recommend you speak to your accountant or an attorney, a real estate attorney, if you have some questions with regards to your own unique situation. First off, before Wesley comes on, I do want to point out that the main changes are, well, the main portability of the California Prop 19 is Californians over the age of 55 are qualified for, can save their tax base ultimately if they were to purchase another home. There used to be limitations on how you would purchase a home or where you would purchase a home before. And now those limitations have been freed up a little bit. We have a little more flexibility. We'll discuss that a little bit. This also applies to Californians who are severely disabled, or the new thing you'll notice are people who have, Californians who have a home that has been substantially damaged due to wildfire or natural disaster. And somebody I spoke to with earlier today asked me about that specifically because they have a family member who lost their home in one of the wildfires we've had recently. And what has happened is when they rebuilt their property, the property was reassessed, and they had bought the house 40 years ago. So they had a very low tax base, and with the reassessment, their taxes were going to go through the roof, and they weren't even going to be able to afford their own home. So that's why this proposition was important for those people. Wesley, I'm going to let you start because you've got, introduce yourself, tell everybody where you're from, and I'm going to let you go ahead with your presentation.
Oh, sure. Thank you very much for having me. My name is Wesley Williams. I'm an attorney here in California. I work with the firm of RELAW, APC. Most of you know Jennifer Felton. Jennifer Felton's been in the industry for quite a number of years. My background is I've been an attorney since 2010. And I've been working in the title insurance industry for a little over 27 years. Prior to becoming an attorney, and that's essentially my background. Okay, so let me see a little bit about this Prop 19. So as you know, Prop 19 appeared on the ballot this last November, and it passed with just a little over 51% of the vote. Essentially, it was supposed to modify and extend the benefits of Prop 60 and 90. Let me see, property tax bill is based on the, is this where I wanted to be? Bear with me. Okay. So bear with me, I'm going backwards. So Jennifer sent me this thing and I reviewed it last minute. So yeah, so basically the intent was to modify and extend Prop 60 and 90 with respect to certain classes of homeowners, particularly, as you mentioned, people aged 55 and over. And so it extended that out. And before we get into the nuts and bolts of it, what I'm going to do basically is explain to you what the original law was and show you what Prop 19 provisions filled in with respect to Prop 13, 60, 90, Prop 58 and 193, which is the 58 and 193 being the parent-child exclusions from reassessment, as well as the grandparent-grandchild exclusions. So let me see. So the large portion of the state's revenue is derived from property tax revenue, as we know, and the passage of Prop 19 will is supposedly one of the largest, tax increases that we've seen to date with respect to real property taxes. And as you know, currently a property tax bill is based on the assessed value of a given property. So when someone purchases a property, the property's assessed value is the purchase price, which was the original basis for Prop 13, right? So when you purchased a property, your tax basis would be when you purchased the home, and if you've owned the home for an extended period of time and intended to transfer it to your children, it would essentially keep the property's tax base as to when you purchased the property. So as you know, here's Prop 13. So Prop 13 was an amendment to the Constitution. Right, amendment to the Constitution, California Constitution, enacted in 1978 by means of the initiative process. The proposition limited property tax increases by assessing values at their 1976 value and restricted annual increases of assessed value of real property to an inflation factor not to exceed 2% per year, and that's relatively steady. So it prohibits reassessment of a new base year value, except in cases of change in ownership or completion of new construction, which is when these reassessments kick in, right? Is when you have a change in ownership. These rules apply equally to all real estate, residential, commercial, whether owned by individuals or corporations. Okay, the initiative also created the requirement of a 2/3 majority in both legislative houses for future increases in the state tax rates or amounts of revenue collected, including income tax rates. So as we mentioned, Prop 19 was to expand on Prop 60 and 90, and Prop 60 and 90, as you know, bear with me. Oh my goodness.
Wow, it popped all over there.
There we go. So hold on one second.
I like how it has the counties below, because Prop 60 and 90 were county specific.
Exactly.
And limited by certain counties.
Correct. And so you can see originally what those propositions were meant to do with respect to say. So here's the imposition of Prop 19 with respect to Proposition 60 and 90. So persons 55 and older, disabled. So it includes now disabled or wildfire victims, as you mentioned earlier, sell his or her primary residence and transfer their tax basis for the replacement property. So equal lesser value can be greater. Okay. Purchased within 2 years. Okay. So these are all what the initial Prop 60 and 90 allowed for, and the red is the new provision. So it's now allowed 3 times in a lifetime, 1 time for wildfire victims within any county now. So it wasn't as before, it was county specific, as you mentioned. Now it's within any county in California.
And Prop 60 and 90 were only allowing a one-time transfer.
Correct. Now
whereas now you can transfer up to 3 times.
Absolutely. And keep the existing basis.
Correct.
Your tax basis. Okay. Right. And we discussed no longer within the 10 counties.
Mm-hmm.
Okay.
Anywhere in the state.
Yeah. So we created some easy examples of how this applies. So in this example, Mr. Smith, age 61, wants to sell his home in Altadena worth $1 million and buy a beachfront condo in Ventura worth $1.2 million. The assessed value of the Altadena home is $425,000. And this is assuming a 1.2% property tax rate. Property tax assessment is $5,100. Can Mr. Smith transfer his current assessed value to the new condo? Yes, he can. And as Thor pointed out, yes. Although there would be some adjustment given that the purchase price of the new condo is higher than the sale price of the current home, the new assessed value is $625,000. So that was the 425,000 former assessed value plus the new purchase price minus the former sale price gives a new property tax assessment of $7,500.
Now, are there some limitations as to the $1 million mark?
Limitations as to the no. That's what the statute states is the $1 million.
Okay.
So new assessed value times the property tax rate. Okay. Bear with me, is there a way to move my little icon? Here we go. Got everything in the way now. Here we go. I can read everything again. Okay, so example, here's the summary of the new one. So the new property tax assessment is $7,500. The property tax assessment would have been $14,400. So the eligible homeowner saved $6,900 per year in this scenario due to the new rules of Prop 19. So these are the benefits of Prop 19 with respect to the transferring the tax base for those certain specific classes of homeowners. So now, California Prop 58, now these are the changes and implementations with respect to the Prop 19 when it involves parent-child or grandparent to grandchild transfers. And, okay. So what it does is in this scenario, so excludes. Let me see. Okay. So under the, I think this is what. Okay. So the PowerPoint gives comparisons now with respect to the parent-child exclusion, which initially it was when it came to the primary residence. Of that.
Oh, there's the $1 million limit exception, correct?
Right.
That's what I was referring to.
Correct. So before, when it came to the principal residence from the parent to child transfer, there was no dollar limit. Now there is a dollar limit. And keep in mind, this is only for the parent to child transfer of the principal resident. Now, what it does, the new law does not take into consideration a couple of things. So if the property owner has multiple children that they could potentially be transferring the property to, there's no really carve out for keeping that tax base with respect to the same. Basically, you have to live at the property. So in this scenario, under the existing law now, as it stands, all the children of the property owner have to reside in the property. At least that's how the rule reads. There really has been no clarification given as to if, in fact, all the children need to live on the property and make it their principal residence in order to take advantage of the exclusion. Correct.
Yeah.
But in this case now, it's limited to $1 million exception. So under this scenario, mom has a primary residence, a $4 million fair market value, and a $500,000 assessed value. Mom also has a commercial property, and keep in mind, with respect to under the old rule, it used to be where they can also, with respect to commercial properties, they could still also take advantage of that tax base and have the $1 million exclusion. In this case, there is no $1 million exclusion anymore. They're going to get assessed. They're going to get reassessed at the full fair market value upon the death or transfer of the property to the children, essentially. So, and in this example, let me see here. We got the mom with a primary residence with a $4 million fair market value and a $500 assessment value. The mom also has a commercial property with a $5 million fair market value and a $1 million assessment value. Property tax rate, 1.2%, assuming total taxes $15,300. So mom, in this scenario, mom gifts son both properties, right? So do the properties get reassessed If so, and at what value? Now, this is assuming this transfer takes place after February 15th, and it does. So
Now, that's the
let
same
me-
thing with the commercial property too. 'Cause
correct. That's
obviously
correct.
not a primary
They
residence.
both do, right. If Sun maintains the property as his primary residence, property owner receives a limit exemption, which is that 1 million from reassessment of the fair market value. Used to be unlimited. Now it's capped at 1 million. New assessed value 3 million, which is 4 million minus the 1 million. Property 2 is reassessed at its fair market value because only primary residents fall under the exception of the rule now. It never used to be.
Mhm.
So new assessed value for the second property is 5 million market value. In summary, you got the, let me see. So new assessed value for both properties is 8 million, increased by 6.5 million. So 3 million for the house and 5 million for the commercial property. New property tax assessment is 96,000, increased by 78,000. Compared to the old rule under Prop 58, the new assessed value for both properties would have been 3.5 million, 500K for the house and 3 million for the commercial property. New property tax is at 35,700. It's an increase by 20,400. You can see how impactful this new law is with respect to these parent-child transfers, where under the old rules, you would essentially get 100% of the assessed value under the Prop 13 transferred to the child if they were going to use it as their primary residence. But under the commercial property, now it gets reassessed automatically upon transfer to the current fair market value.
So Wesley, I just want to ask you a question. Maybe you can answer this for me. Some people will say to me, I don't have to worry about this because I fall under Prop 13. Okay. And I try to explain to them this is modifying that original Prop 13. And there is a struggle to maintain that Prop 13 integrity at all. But
Yeah,
what would you tell them?
Yeah, they're going to find it extremely difficult. I mean, all the assessors are gearing up for how much of how many properties are going to be getting reassessed because of this new rule, and it's not like they're not going to inquire. So ultimately, with respect to these parent-child transfers of the primary residence, the child is going to have to elect as to whether or not they're going to stay and live in that property. They're going to have to file a homeowner's exemption with the assessor office, the county recorder office. File that homeowner exemption to take advantage of the new rules with respect to the transfer of the assessed value, and ultimately, if they decide to move out of the property and no longer make that their primary residence, then it will get reassessed at the current fair market value. So it sounds like they're gearing up to be extremely strict on these rules.
Yeah, and I did take a look at some of the paperwork, and in case anybody is wondering, this is not automatic. They don't automatically look and say, oh, this person is 65 years old, so we can assess it this way. You must apply for the exemptions.
Correct.
So a lot of people make that mistake. They think it's done, and it's not something an escrow officer does. It is something you personally do.
Correct. And just to kind of recap on the expanded rights under Prop 60 and 90, starting April 1st, 2021, the measure expands the special rules for eligible homeowners, like I mentioned, 55 and older, victims of wildfire, etc. Eligible homeowners can keep their assessed value property taxes when moving to a new home, correct? And then let me see. Eligible homeowners can move to a more expansive home. There would be some adjustment, but less than before. Okay, and homeowners who are 55 or severely disabled, that's what I didn't mention, could use the special rule 3 times in their lifetime, as we mentioned. Okay, and to recap, the narrowed rights under Prop 58 and 193 with the parent-child and the grandchild exclusions, starting February 16th. Well, it's February 15th and 16th. The measure 15th was a holiday, which is why we had the 16th. Starting February 16, 2020, the measure narrows the special rules for inherited properties, as I mentioned. The transfer of real property used for a purpose other than the principal resident from parent to child or grandchild shall be reassessed to market value, as I stated. So if you're dealing with a property that is used for income producing properties, things of that nature that aren't going to be used as the primary resident from the actual parent to the child that's going to use it as a primary resident. So they both have to meet that qualification to become eligible. So this has to be the property owner's primary resident, and that the child will make their primary resident as well in order to qualify for that the exemption under this new rule. And so keep in mind that, like I mentioned before, you got to make sure that the child is going to use that property as their primary residence now. And like I said before, there hasn't been any clarification as to whether or not the child or children all have to live at the property in order to benefit from from this new rule. And that's, like I said, but as the law is written now, it appears that all the children would have to live at the property in order to qualify, which is so bizarre. But we'll see what happens. Each of the county recorders, or excuse me, each of the county assessors' offices is doing something a little bit different as to how they're interpreting that rule. But ultimately, like I said, we're going to wait and see what the Board of Equalization has to say about that. And then let me see.
Is that who we follow the most, is the Board of Equalization? So as the counties are interpreting things differently, the Board of Equalization will clarify, correct?
Correct.
Okay.
Great. So the transfer of real property, let's see, the transfer of property used as a primary residence from parent to child or grandchild shall be subject to the limited 1 million exemption, as I mentioned. This is just for the primary residence. Used to be unlimited, now it's only 1 million. And that's essentially the high-level overview of the changes.
Well, hopefully everybody's with us and their eyes are not rolling up inside their head, because I know that it's a lot of information and it's a little bit daunting.
Yeah, I mean, it seems like, like the old adage, the tax man is eventually going to come a knocking at some point. And at this, this is this point in time where you're going to actually have to make preparations on how to prepare for these things. And ultimately, the window of opportunity was very short. We'll see how how this progresses in the future.
Well, we do have I do have a question from Robin. Robin, do you want to unmute yourself and ask your question?
Sure. Wesley, we sold our home in Simi Valley 5 years ago. We were in it over 31 years, and my husband was actually over 60 when we sold it. And we built a home up here in Northern California, but Solano County at the time wasn't accepting our tax base, so we couldn't transfer. But now that is it all counties that are accepting it now? Would it be possible for us to check into it to see if we could have it changed? Because our property taxes are really high compared to what we were paying in Southern California.
It's possible. Our firm doesn't do that sort of work, but I know there are other firms that will actually do, and they can appeal a lot of these property tax assessment issues. Like I said, it's possible that it's retroactive. So I mean, that's something you may want to look into.
Okay, great.
That was 5 years ago or 6 years ago already. What if I had somebody who closed escrow in December, let's say, and have moved out of the county, and their new house is not ready until maybe next month? Will it have to be after that April date? Because isn't there an April date?
Yeah, that's when the new laws take effect. So after that date.
So if they close on their new build, which is not built yet, after April, they would qualify, wouldn't they, for the transfer?
Absolutely. Yeah.
Okay. Anybody else have any questions? Feel free to unmute yourself. We want to make sure we answer anything we can.
Okay, I do have another question. My mother-in-law lives in Canoga Park, and my brother-in-law, my 73-year-old brother-in-law, lives with her.
Mhm.
I believe she put his name on the house, but her name is still on it also. When she passes away, and the house completely transfers to Ray, or is it basically his house when she passes away and he won't have to pay anything?
I mean, are they holding title as joint tenants, or what's
Yeah, it
their?
depends
Mike
on
and I
how
are going to
titles
find that out when we go
Yeah,
down there.
I mean,
But
you
then-
still have rights to survivorship and things of that nature. This is these are really parent-child transfers.
Right. Right. And if we were to have to sell her home to put her into assisted living, that would be a whole different story, right? We wouldn't, because that money would go in like a trust to pay for her assisted living.
Yeah, I'd have to know more facts of how all this is structured and see what
Okay.
what the intent is to for that purpose. I don't know at this point.
Right.
It is a little different when it comes to the trust and with a surviving trustee.
Right. Right. Yeah. I mean, like I said, if the property is currently in a trust and you had the property in a trust
Mhm.
prior to the 15th date, depending on whether or not it was a revocable, irrevocable trust, that could trigger, if it was done prior to the 15th date, then you're okay. Depending on if it's done after the fact, in other words, putting your property into a trust after that that February 15th date, it's the property is going to, if it's an irrevocable, the property is ultimately going to appear as being transferring to the child and ultimately reassessed at that point. So I mean, you got to really consider how these you're going to structure the transfers at a later date, and whether or not the transfer is going to appear as a gift or a transfer to the new to the new child, to the child, in other words. So I mean, you really got to look at how you're structuring these transactions to make sure that that doesn't involve in a current transfer to the child. If, in other words, if you're putting the property into an irrevocable trust, because it could trigger the reassessment.
Thank you.
Does anybody else have any other questions? You can put it in your chat box or feel free to unmute yourself and ask.
I also want to let everybody know in the chat box, there is the website for the State Board of Equalization, so you can check it out and keep updated with any changes.
The forms are there also.
Mm-hmm.
Let me
Yeah.
stop. Here, I can stop screen sharing now.
Well, thank you very much, Wesley. I really greatly appreciate you joining us. And everybody who did pipe in, I do want to encourage you to say, share this information with people who may be in a situation. It's interesting conversation for people may not know where to reach out. And like I said, some people are under the impression they still fall under Prop 13 and nothing has ever changed. So the fact of it, the reality is it does change, and these propositions do modify each other on and on. So we want to make sure everybody's protected. And at the same time, if you have any questions specific to your unique situation, contact me. I'm going to put you in touch with the right people, and make sure that you're always talking to your tax accountant or your legal representative before making any decisions on how you want to move forward. So if that's
Cindy,
it, yeah.
If you'd like, I can send you a copy of my PowerPoint, and if you'd like to distribute it, that's fine.
Oh, thank you, Wesley. That would be great. I know you have Mandy's email, so go ahead and do that, and we'll make sure we have that available. We are going to be posting this on our website, and we do have a video library so that we've got information available at any time. So if you ever need to revisit it and maybe look at those PowerPoint pieces and do the math, because that's always fun. So, okay.
Right.
All right. Well, if that's it, I want to thank everybody for coming. Keep an eye out for some of the other topics that are coming up we're going to try to answer questions and bring something of value to you all the time. So
Thank you very much.
okay,
Thank
good to
you for
see
having me. I
everyone,
appreciate it.
and you guys have a really great rest of the day. Okay,
You too, Cindy. Thank
take
you.
care.
Thank you.
Bye-bye.
Thanks,
you.
Leslie.
Thank you.
Thank
Bye-bye.
you, Wesley. Bye-bye.